The last case then is from a decrim immigration, as I always like to go without getting too much into the weeds. And that was not pun intended, but I wish it was, because it is on the weeds. It's Syed v. U.S. Attorney General out of the 11th Circuit. Shout out to David Stoller in the Central Florida area for this win on the big issue. That is the huge issue that the 8th Circuit said in Gonzalez v. Wilkinson, that the board said the other way in matter of Guadarrama. Florida's possession of marijuana statute crime is not a removable offense. It's not a law relating to a controlled substance. And that is because Florida's definition of marijuana is broader and covers more conduct, covers more plant than the federal definition. That's because Florida criminalizes technically possession of the seeds and the stalks of a marijuana plant, and the federal government doesn't.
Oh, really?
And even though there is probably no case where Florida has punished it, and who knows, no one can find it, Judge Choflat, who is no progressive on criminal immigration issues on the 11th Circuit, Judge Choflat authors the decision, says, we don't care in the 11th Circuit. If the statutory text itself is clearly overbroad, you don't have a categorical match, and the realistic probability test and the need to find a case where the law is applied in an overbroad manner, it doesn't apply. And so Florida's definition, that is the text, marijuana is overbroad. It covers the stalks and seeds. The feds don't, case closed, unless Florida's definition of marijuana is itself divisible. That is possession of, I don't know, the marijuana, the flower is different. God, I'm such a loser. Well, the marijuana flower is different than the marijuana stock, and it's not, because I mean, of course it's not. And so it's a huge decision for non-citizens in the 11th Circuit, possessing marijuana, all that. So for both relief, this is in the relief context too. So it's not going to preclude you from relief, and it's not going to make you removable, for example. But it's also big because there's been this whole argument in the 11th Circuit in whether or not its seminal decision in Ramos v. U.S. Attorney General, which is a Kurzban law firm case, whether that is still good law. And the board really went out there in matter of Guadarrama in 2019 and said, the 11th Circuit, it's not good law anymore. The 11th Circuit doesn't follow it. And I didn't think that was right. A lot of people didn't think that was right. And in this decision, the 11th Circuit's making pretty clear that, no, Ramos is good law. You don't need to find a case if the statutory text itself makes the statute overbroad. And so it's a huge decision in the 11th Circuit. Props to David Stoller. It's been an argument that a lot of people, Mike Vastine, Mary Kramer, a lot of people have been arguing for a long time. And finally, the 11th Circuit bit.
Very good. Very good. I mean, especially that area of Florida, there's going to be a lot of people who get helped by this. This is good stuff.
The whole marijuana dispute is a bit silly to me. I mean, you got the House decriminalizing it for the second time, but it's not passing the Senate. I mean, everything with marijuana seems to be changing, but until it changes federal, it is just a grenade for non-citizens who do it, who smoke marijuana, possess marijuana in a state where it's legal, even if it's legal there, it's still a grenade for immigration purposes. So hopefully it gets
legal here. If it's illegal in your country and you get caught, that's still like going to be filing the crimes there. So
that too.
It has to be a global kind of thing that pops up. If you got a caution in the UK for example, that's going to follow you as a conviction. Yes,
but I feel like if the House has decriminalized marijuana, but it's not going to pass the Senate. But if it does pass the Senate, if marijuana is no longer in the Controlled Substance Act, then I believe that would probably make it no longer a removable offense. So it wouldn't matter if you got it in England or another place because it's not a removable offense here. I think that's how it would work. Hopefully, I mean, you got to take it out of the CSA, and from there, all immigration results follow.
Yeah, it goes out to my experience, but then they also could get you for a year for. I guess they can get you for like the health reasons that they get you sometimes. So that would work either.
I guess they could get you for health.
Because there's some people like have like very minuscule marijuana convictions or minor stuff, and then they're like, oh, immigration crashes. There's like this famous case of this Israeli scientist that was a scientist on marijuana, and he did a marriage adjustment case, and it was denied, and he was removed because he was a scientist in Israel on this stuff. That was in the news and stuff. So it's like the permutations of it are pretty drastic. He didn't know. He thought, I'm a scientist. What are they gonna do? Like, nope. It's black letter law. It's like open and shut. You're out.